Hello and welcome everyone to this webinar on the new proposed anti-clawback regulations. I am the CEO of Interactive Legal, Vanessa Knega. I am so happy to be joined today by our panelists, the renowned Martin Shankman, Jonathan Blottmacher, and Professor Mitchell Gans, who is unfortunately not able to appear on camera, but he is here with us as well. Before we get started with today's webinar, I am going to turn it over to one of our co-sponsors, Nicole King of Peak Trust Company. Nicole, tell us a little bit about Peak.
Thanks, Vanessa. Welcome, everyone, and thank you for attending today's webinar. My name is Nicole King, and I'm a trust officer here at Peak Trust Company. And we, as always, are pleased and honored to be able to sponsor today's presentation. A little bit about Peak. We offer a full spectrum of trustee services serving individuals, families, and their trusted advisors. We offer flexible and customized administrative services for all types of trusts. Currently, we are in Alaska and Nevada, and this summer we're excited to announce we're expanding to Delaware. So I invite you to visit our website, and if you have any questions, please feel free to reach out to me. Thank you.
All right, thank you, Nicole. And before we get started, I did just want to say that another one of our sponsors is, of course, Shankman Law. You will be able to find the recording of this webinar and other past webinars on interesting topics on the Shankman Law website, in addition to the Interactive Legal website at interactivelegal.com. So with that, I will go ahead and turn it over to our panelists. And I believe, Jonathan, we're going to start with you.
Now, this is a very, very interesting and important topic, and I want to give just about 60 seconds of background. Before 1977, we had different systems for estate and gift tax. Although certain lifetime gifts could be brought back into someone's estate, the estate and gift tax systems were different. They had different exemptions, and they had different rates. That all changed in the Tax Reform Act of 1976. When the estate and gift tax provisions were unified, and they had one rate, and the basic way it worked is that any lifetime gift which was not brought back into the decedent's estate as a transfer with a retained income interest would be, that transfer was called an adjusted taxable gift. It was a taxable gift which was not brought back in the estate. And in order to compute the estate tax, you would take the adjusted taxable gifts and add it to the taxable estate, and then apply the unified rate to that. And because you'd included those lifetime gifts called adjusted taxable gifts that were not included in the estate, you got to subtract out the gift tax that was payable on that. And a couple of issues arose. Well, what would happen if the rates were reduced and you paid gift tax at a higher rate than was in effect at the time that the decedent died? Well, the law said we will use the rates in effect at the time of death. So even if you paid at a rate of 60%, if you died when the rate was 50%, your basic deduction or credit, so to speak, would be at the 50% bracket. The other thing is, what would happen if the exemption were reduced? Because you only got one exemption. And even if you'd used your exemption during lifetime, you got to use it when you died. And the reason it doesn't count as double counting of the exemption is because you added those taxable lifetime gifts, the adjusted taxable gifts, into the base upon which you applied the rate. Well, back in 2010, we thought that the exemption was going to drop. And people said, my gosh, it's going to drop from 5 million to 1 million. Is there a way I can preserve it? Could I make, for example, a $4 million gift and preserve the $1 million exemption that was going to exist after the law changed? Well, we never really found out because they kept the exemption at 5 million. But now we're facing it again in two ways. Number one, built into the law, the current exemption, which is $12,060,000, which is up from 10 million, inflation adjusted, from 10 million to $12,060,000. That is slated to be reduced in 2026 to $5 million adjusted for inflation. Moreover, as you all know, there have been a number of proposals which reduce the exemption down to a much smaller number. Some cases it would be 5 million, which is supposed to happen in 2026, but some proposals said it will drop to 3.5 million. And the question comes in, well, if I use my exemption during my lifetime, and is smaller, do we claw back the exemption that is used? And Congress passed a law instructing the Treasury to come out with regulations on that. And basically, in a broad sense, the regulations which have been issued that are on the books right now saying, no, we do not claw it back. It's an anti-clawback regulation. But the new regulations that we're going to talk about today don't allow the anti-clawback provisions to occur. In other words, in some circumstances, under these new proposed regulations, the exemption can be clawed back. Now, Marty, tell us about some of the terminology that we have to know in order to understand these proposed regulations.
So I added this slide when I was taking a final run through the program, preparing for the program, and it dawned on me how complicated and odd the language is that we're using. So it may be simple to some of you, but I found it odd, and I thought this may be helpful. And Jonathan has explained some of the concepts, but just a few points. We may refer to the bonus exemption, the increase from 5 to 10 million is bonus. That extra 5, and I'm leaving out the inflation adjustment, is sometimes referred to as bonus exemption, and that's what sunsets after 2025. Clawback, Jonathan explained, is that the exemption, if you make a $10 million inflation adjusted gift, $12,060,000 in 2022, and the exemption's $5 million inflation adjusted, let's just use the 10 and the 5 without the inflation just to make it easier. And if that exemption were clawed back so that you'd only get the benefit of a 5 million exemption once you've added back the gift, that exemption in effect would be clawed back. The regulations that Jonathan mentioned, the first set of regulations, were issued in 2019. Those regulations are referred to as the anti-clawback regulations. And those regulations do, just as Jonathan explained, backstop the statute. And we're going to explain some of the basis for all this in a few minutes. And they backstop the statute by saying, no, you don't claw back the exemption. So if you used a $10 million exemption when the gift is made, then you're not clawing it back. You'll get a 10 million exemption, even if when you die, it's only 5 million. Those are the anti-clawback regulations, 2019. Now, proposed regulations were just issued, and the proposed regulations get special rules that provide exceptions to the anti-clawback regulations issued in 2019. So in general, you're not clawing back the exemption, meaning you won't lose it if you die and the exemption's lower than when the gift was made. That's the proposed rules, proposed regulations that give exceptions to the anti-clawback. Now, just to make sure you're enjoying this, the proposed regulations have exceptions to the exceptions, right? We love this stuff as tax attorneys, exceptions to the exceptions. If there's an exception to the exception in the anti-clawback proposed regulations that just came out, then in fact, the new proposed regulations that would otherwise have the clawback apply, i.e. not have you under the anti-clawback regulations, won't apply, and you'll be back under the anti-clawback regulations. So there's exceptions to the exceptions. The exceptions provide you're subject to clawback because they're exceptions to the general regs issued in 2019. The exceptions to the exceptions permit you to retain or have safeguarded the exemption. I don't know if that made you more confused or if that helped, but I thought it would be useful to try to lay out some of the terms. Now, it looks like, and please, Jonathan Mitchell, interrupt me all the time, please. Don't be shy, Jonathan. The proposed regs, if they're adopted exactly as they are, and I don't think there's, I would suspect that we're going to have some changes and clarifications. But if they're adopted as they are, and that's what we're going to assume for our discussion, a lot of the estate planning that was done seems to be okay. If you made a gift of a completed gift to a self-settled domestic asset protection trust, a completed gift, that would seem to be okay. If you made a gift to the SLAT, Spousal Lifetime Access Trust, and presumably a SPAT, Special Power of Appointment Trust, these were the common trusts that were used frequently in 2020, 2021, and even it spilled into 2022 planning, it would seem those should be fine. So in some respect, the proposed regs weren't as harsh as some people feared, but there are some very significant proposals that do harshly and adversely affect some of the planning that was done over the past few years, again, trying to secure that bonus exemption that Jonathan spoke about. So they weren't as bad as some people feared. They do have some very significant issues and concerns, and we're going to go through those in our discussion. I think the bottom line for us as practitioners, and Jonathan may want to elaborate, but proposed regs don't have the force and effect on law. We can't and shouldn't tell clients change what you've done because of a proposed reg. But I do think, and this is the second to last bullet point, we do want to communicate to clients, whether in memos, emails, firm newsletters, that, hey, this stuff is out there. Here are some of the transactions that may be affected. You really should call and review this with us and start to devise a plan on how to deal with it in case these regs are finalized, where any changes, the last bullet point, that may occur between the proposed regs and final regs won't change the impact on a client. So we'll talk about some of these as we go, but if you had a large promise gift, and we'll define and explain that in a minute, I think you want to confirm with the clients that they're aware that there are proposed regs that may change the consequences of that. And then you can meet with them and come up with a strategy. But again, one of the issues that Jonathan and I and Mitchell have seen in some of the malpractice cases that have been out there is that one of the themes is, and I'm not saying we have an obligation, I'm not at all saying we have an obligation to communicate law changes to clients, but one of the themes that comes up in some of the malpractice cases, clients claiming you didn't tell me. So I think it's important to let clients know, if you know you did these types of transactions, or even a generic letter to at least alert clients that some of these plans may not work. Jonathan, do you want me to talk a little about the 2017 Tax Act, the basis for the regs, or you or Mitchell want to cover that? Mitchell?
Yeah, Mitchell, why don't you cover it?
No, I'm going to let you do it, Jonathan.
Well, let me make one preliminary remark again. I made one before, I'll make another one. Let's say you had done a transaction which is now going to be clawed back because it falls under these proposed regulations. And those we'll get into some details, but basically if you make a transfer that would come back into your estate because, for example, you retained an income interest in it, even if you'd done it last year, if you die after 2025, it's going to be clawed back, not just be put into your estate, but you're going to lose the exemption which you used when you created the gift. That's very important to understand. Don't think, oh, we did our transaction, we're grandfathered from the clawback. You're not, because under these proposed regulations, certain types of transfers, generally transfers which would come back into your gross estate. So you not only have a larger estate, but you do not get the benefit of having used the exemption when it was larger. You're going to be stuck with the exemption at your death. That's very important to understand. So even if you've done something with a client, you say, heck, we did it 2 years ago, we're golden, we've used that exemption. If the client dies when the exemption has been decreased and that transfer comes back into your estate, subject to the exceptions which we'll talk about, you're not going to get the benefit of using the bonus exemption. Now, the regulations provide. Go ahead.
I apologize for interrupting. Please forgive me, but just something is percolating that I'm not sure I've heard talked about. And I know this is not the right place, but I don't want to lose the thought. If I did a promise gift, and we'll talk about this, everyone, in more detail and explain in a minute, but I want to highlight a point that Jonathan made, that if you did a transaction 2 years ago, you're not safe, you're not grandfathered. If it violates the types of transactions these proposed regs are after, you're going to only end up with the exemption at the date of death. But let's say I made a $10 million promise gift. I filed a gift tax return. I reported it as a completed gift. Even leaving aside the 18-month rule and that I could pay it off, if a client made a transfer 2 years ago, and like you said, it's not grandfathered, and you're correct, it's not. There's no get out of jail free here. What do you do now? You can't really, I mean, can you go out and do another gift, but you don't have exemption? You kind of used your exemption. Is there a way before the end of 2025? What do you do to try to safeguard the exemption if the prior gift doesn't work under the proposed regs? Am I making sense with that? It's like if I didn't make the gift, I could do a gift now. But if I've made the gift, but it's not going to work, do I have exemption I can use? Or am I in a worse position?
Well, Marty, as you know, you're not forgiven. You can't use it again. You've used it, and there's nothing you can do except maybe find an exception to this exception. But let me point out something. Marty talked about making basically a promise gift. What that means is that you made a gift by making an enforceable promise. Throughout the United States, if I make a gift, I promise to give Mitchell $5 million by the time I die. I, from state law perspective, may have made a gift, but that doesn't count as a transfer for estate and gift tax purposes because it's not enforceable. When someone makes a promise to you, unless you provide some consideration, it's not enforceable except in the state of Pennsylvania. Pennsylvania has a statute which says if you put your promise in writing and you basically say, and I really mean I'm going to pay this off, then you've made a gift by promise. Another way you can possibly do that is that you make a transfer of consideration for the promise, but it's de minimis in size. For example, I promise Marty that I will give him $10 million within the next 5 years, but only if he comes over and cooks my dinner tonight. And Marty promises he will, in fact, cook my dinner tonight. Marty's promise back to me is consideration for my promise to him to pay him $10 million within the next 5 years. He doesn't actually have to do it. It's just his promise constitutes consideration, even though, and Marty, by the way, is a great chef, but it's not worth $10 million. So I am going to make a gift because when you make a transfer, and here you're making a transfer by promise, your gift is equal to the value of what you've transferred, which is my promise to pay $10 million within the next 5 years. And what I subtract from that, the value of what I got back, which is that Marty's promised to make my dinner sometime in the next, say, year. And maybe that's worth $100. So I've made a transfer worth maybe $10 million. I've gotten back $100. So I've made a gift of $9,990,000. But that's where you are. But Marty, you're absolutely correct. If you make any sort of promise which is enforceable, you will have made a gift. Or if you've actually made a transfer, but it's going to be includable in your estate because you've retained an income interest or power of control over it, it means that you're going to have made a gift, but that gift can't get undone. You can't say, well, gee, now I know that if I die after 2025, I'm going to have my exemption clawed back because I retained an income interest in it. Well, guess what? You can't make another gift and use it saying, but that one won't count. The first one I made doesn't count. So
let me just jump in here on that. Can I jump in on Marty's hypo?
Please,
of course.
Okay, great. So I think that's a really interesting hypo, Marty. You know, a year or two ago, you gave this note in reliance on existing law, and you thought you'd be okay. And now all of a sudden they come along with new regulations now saying you're not okay. And I find that interesting and troubling. So one thing that occurs to me right off the bat is the 18-month rule, which we're going to be getting to in a little while, I assume. But, you know, under the 18-month rule, what you could do is you could repay the note. And then if the client lives for 18 months after having repaid the note, it's gone. You now have locked up the exemption. It worked. So no one's taking it away from you. In fact, when we get to this, I had planned to suggest that I think they've blown new life into the promissory note technique with these regulations through the 18-month rule, which we can talk about later. I mean, it just seems to me that it's probably for people who are concerned about this, want to try to lock up the exemption. They give a promissory note, and then years later they can decide whether to make it work or not by trying to repay it, provided they live for 18 months after they've repaid it. So I think that's interesting. The other thing that occurs to me about this, which is really provocative and interesting, is I wonder if there's and I'm just speculating here, I'm way off in the speculative realm, but I do appreciate the unfairness inherent in your hypo, that someone relied on existing law and then the rug gets pulled out from under them with these, in effect, retroactive regulations, right? Because these regulations are going to be effective for people who die after the date that they become final, I suppose. So, to the extent that one could argue that there's a retroactive aspect to these regulations, which is what your question cues up, I think. Could it be argued, I'm raising the question, could it be argued that the Treasury and the IRS don't have authority to do that? Because under Section 7805, as we all know, I'm looking right at you, Jonathan, as we know, the IRS and Treasury do not have the authority to write regulations on a retroactive basis as a general rule. And so the interesting question becomes, what do we mean? What does the statute, what does 7805 mean when it prohibits the issuance of retroactive regulations? Is there an argument here that maybe this has a retroactive effect such that it is prohibited by this provision in 7805? I don't know. I just raised the question. If you guys have any thoughts on it, be interested in hearing them, of course. The other thing is that there's also this concept of abuse of discretion that comes from the Administrative Procedure Act. So even though 7805 of the code may authorize these regulations, and even though it may not be retroactive within the meaning of that section, nonetheless, maybe there's an argument that a regulation like this, given the reliance interest, given how people relied on existing law, maybe there's an argument that it would be an abuse of discretion. I'm doubtful either of these arguments would work, but I do think that the hypo does kind of call for these kinds of, this kind of analysis.
Mitchell, I think you're right, and I'm not sure that this is the kind of retroactive regulation they're talking about. I mean, they're going to say that this is a new regulation and we're just deciding whether or not you get the exemption or not. And remember, this comes out of a law that was passed in 2017, giving the Treasury some authorization on these matters. But you're not actually making it all retroactive. You're just saying that if you die after the exemption has gone down, in computing your estate tax, we're not going to allow the exemption that you used during your lifetime, but only use the exemption that's in effect at death. Now, let me make a point here. Let's suppose you made a gift of $10 million using your exemption, and you die in 2024, and you die, and let's say you have another $40 million in your estate. What you're going to do is you're going to take that $10 million adjusted taxable gift, the gift you made during your lifetime, and you're going to add your $40 million taxable estate. So you now have a $50 million base. You'll compute the tax and you'll subtract out the gift tax, which would be payable under the rates in effect at your death on the $10 million gift. And then the question is, how much exemption do you get to apply? Well, we'd like to think, well, gee, you use the $10 million exemption, and if you die in 2024, you will get to use that $10 million exemption. But if you die after 2025, it appears that unless you fall under an exception where it comes back into your estate, you're only going to be able to use the exemption that's in effect at the time that you die. That is how it works. And Mitchell, great question. People will argue that this was basically unfair, unconstitutional, beyond the scope of 7805, but we'll have to see how it comes out. But in your planning, don't rely on your being able to win the day because they've got some sort of retroactive regulation. The regulation isn't retroactive. It just says that when you die, instead of using the exemption that was in effect at the time you made the gift, we're going to make you use the exemption that's in effect if you die, if you fall under these exceptions to the anti-clawback rule, which, and I'm just going to go through these briefly so people understand them. One is if you make an enforceable promise that constitutes a gift, it's going to basically be undone. You're going to have to use the exemption in effect at your death, not the one that you used when you made the gift by promise. Also, if you make a transfer where you have retained an interest under 2036, 2037, 2038, or 2042, the life insurance, it means that you're going to have to use the exemption in effect at the time you die. Now, if you die before the exemption drops, you don't have anything to worry about. But if you've tried to use the exemption now during your lifetime and you die after the exemption has gone down, you're going to be stuck in computing your estate tax with that lower exemption unless you fall under an exception to the exception, like the 18-month rule, which we're going to get to, or the 5% de minimis rule, which we'll get to. Marty, back to you.
So again, I don't know that we have an answer. Mitchell has raised some interesting thoughts, but it seems that Mitchell and Jonathan both agree you can't necessarily rely on it. So it sounds like if you did one of these transactions in the last couple of years trying to preserve exemption, that you may not be able to preserve exemption, but you've made a gift using your current exemption, so you can't just unwind the gift saying, gee, you know, I made this promise gift or this GRIP partnership structure, and we'll talk about that. And golly, now that I know that these proposed regs say it doesn't preserve the exemption, I want to unwind it. It doesn't seem like there's a way to necessarily unwind it, and your client is now stuck with a worse position than had they not done any planning. Had they not done any planning, they could make a simple gift to a SLAT or a DAP now and lock in the exemption. But because they use more creative planning, because you were doing a better job, perhaps, it's not going to work. That's troubling a little bit. So
Marty, there is some law around. I'm not sure what's worth going down this road for much, but there is a little bit of law around that talks about how maybe you could undo or rescind the gift if it was made on a false premise about what the law would be. And so if the law changed, you know, I think there's a case in the Third Circuit called Neal that kind of gets into that. There's also a case, I think it's a district court case in Massachusetts, the brake iron case, if I recall correctly, which kind of touch on this. So that's kind of an interesting thing. But I think in general, I agree with you. You're in a tough spot.
I would love to hear in another time, because we have so much to cover today, your thoughts on how you could undo a gift, because they've kind of changed the ground rules of the law, and the law was uncertain. That's a fascinating thing, and I think that's something the profession's going to have to put some attention on if these are finalized, because that may be the only way people can get out of the pickle they're in. And they're in a pickle because they did a promise gift or a GRIP or something that sounded very plausible, and they had basis for it. And now the IRS says you're not going to be able to preserve your exemption. You know, we can always evaluate the 18-month rule and stuff, and we're going to talk about that. But we may have some clients that are going to be very unhappy. And now that we're thinking about this out loud, and it's funny, I did a program on the same topic, and this issue didn't come up before. But we may have clients that, because they did creative planning with us, are in a worse position with less options and likely not being able to preserve their exemption. And that's something we're going to have to address.
Marty, before you go on, why don't you tell everybody what a GRIP is?
We're going to come to it. We got slides.
Yeah, but just tell them what it is, because you keep talking about it, and a lot of us out here don't know what that means.
I know you know what it means, Jonathan, better than I. We're talking about a defective partnership freeze. So, and I don't know if they included GRIT, a defective GRIT in the same concept. You make a transfer with, like, say, a preferred partnership, and it's the calculation of your gift is based on the subtraction method. The full value of the gift, the value of the asset transferred, less your retained interest. But you only can subtract out your retained interest. A value can only be assigned to it if you meet the requirements of the regulations of being a qualified interest. So if you intentionally blow or violate the requirements to be a qualified interest, then the retained interest is zero. So the full value of the transfer is deemed to be a current gift. Now, in prior history, before the last few years when people were struggling to use exemption, you would plan affirmatively not to violate those rules and to make something qualify as a qualified retained interest, so you could deduct it out. But now in the environment we've been in for several years, where there were these great concerns, as Jonathan explained, like under the Sanders tax bill, where you could have had $1 million gift exemption, people wanted to use exemption. So we intentionally structured a transfer where I would give away an interest, say in a partnership, retain a right to income or a preferred return, intentionally violate the qualified requirements for qualified interest, so that the full value would be attributed to the transfer. I'd use up that much exemption, but I still had the income coming back to me. That's the kind of transaction that the IRS was looking to address in the proposed regs. And we're going to go through all this more thoroughly. And I apologize to everyone in the audience that my fault, I sidetracked us, but it just dawned on me the pickle that some clients may be in because of the prior planning they've done. And I thank Jonathan and Mitchell for their insights on that. And that's something we're all going to have to explore further as a profession if these proposed regs are finalized, because a lot of clients are going to be very interested. Jonathan and Mitchell, do you want to make any more comments, or should I go back to the slide deck and move forward from there?
I think you can move forward, Marty.
All right, so let's go back, and sorry for the sidetrack, but I just thought it was interesting and I didn't want to lose the thought, everybody. So in 2017, the Tax Cut and Jobs Act that was enacted, the Republicans were very aware that, golly, if we put through this doubling of the exemption, this bonus exemption amount, that if the Democrats take over, which is in fact what happened, they may try, which they in fact have tried, to change the exemption amount, and then the benefits of people that did this planning would be lost. And they didn't want that to happen. So in other words, if you use the $10 million inflation adjusted exemption and made a gift, an outright gift, a gift to an irrevocable trust like a SLAT or ADAPT or something, and you use your exemption, what the Republicans didn't want is then the Democrats change the law, just like we're dealing with this anti-clawback, but it's very limited to the transactions it affects. And now you lose the higher exemption that you in good faith used before. So they ideally would have liked to have just said, hey, you can't claw back the exemption, but they couldn't do that because of the Byrd rule. So if there's a tax reduction, it's got to be capped, limited to 10 years, unless they get at least 60 votes. And when I get through the thought, Jonathan may want to elaborate some more on it. So because of the Byrd rule, they couldn't just bake into the 2017 Tax Act no clawback. So what they did is they gave the Treasury authority to issue regulations to deal with the issue of clawback. And I've quoted the quote section at the bottom of slide 10 that talks about this. So they were going to issue these regulations, and that's in fact what the Treasury did. The 2019 regs basically say no clawback, which is consistent with what the intent of the statute was. But then I guess, and Jonathan and Mitchell may have more insight than I, because some of the articles and comments about some of the types of planning that was being done, the Treasury then came back and issued proposed regulations that make exceptions from the general regs that give you the anti-clawback rules. Jonathan, Mitchell, any elaboration on any of those points? Jonathan?
No, go ahead, Marty.
So let me give you a theory, folks, and Jonathan Mitchell can chime in. I think that the service reads Lineberg. I think they read the Lissy articles, because a number of these techniques like promise gifts, grips, they all had very extensive, brilliantly written articles in Lissy. So, maybe that's where they pick up on some of these planning concepts.
Marty, I think that's exactly what happened. I think that the regulations are drafted basically to close down a couple of different strategies. I think that's what happened. They drafted some rules and law around it, but the bottom line is, I think it was all aimed at closing down a couple of transactions, what you call the GRIP, the promissory note, anything that would have been includable in the gross estate, a GRIT. I mean, these basic ideas were the ones they wanted to close down, and that's what they tried to do. I'll give you this theory. I think what happened was they were trying to say that you can't capture the exemption, you can't lock up the exemption. if you continue essentially to have access to the assets or have practical or de facto ownership of the assets. That's what they were trying to do, I think. And then they grappled with, I think, how do we say that? How do we use existing law to accomplish that? And so the first idea was, well, if it's going to be includable in the gross estate through a section like 2036 or 2038 or 2042, then we can say you've really retained ownership, you really haven't given anything away, and therefore you shouldn't have the exemption. And I think that's what they essentially tried to do. But then I think they introduced, I'll come back to the 18-month rule, which we'll talk about, which seems to be, I think, in conflict with the 3-year rule that we're accustomed to in 2035. I think they raised some issues, but essentially, I think they tried to, base it on a predicate of existing law, which says in certain instances, right, you've retained a right or an interest, and we're going to treat you as if you own it at the time of death. And I think that was the key concept underlying the regulations.
Just to elaborate, and I know it's coming up on the slides, but since Mitchell brought it up and all good points, conceptually, some of the words I've heard used to describe what Mitchell just said about the proposed regs and their intent is they were trying, the Treasury was trying to prevent you from locking in exemption, meaning that it's going to be clawed back, where you made a gift that was a painless or artificial gift. And those are the two words, painless and artificial gift. So if, for example, I set up a preferred partnership, retained a significant income interest, and intentionally violated the qualified interest rules, or I made a promise gift. Promise gift is perfect. Jonathan's example earlier, he promises to give me $10 million. I should only be so lucky if I'll go and cook dinner in the next year for him. Well, Jonathan keeps all of his assets, but yet he's arguably used up his exemption amount, but he's used his exemption amount without giving up any of the liquidity or assets that he has. That's the kind of painless or artificial gift. And those terms, I think, describe what Mitchell just said, and that's what they're seeking to attack in these recently issued proposed regs. But as we'll see, they, as so often happens, get a little bit broader and start to perhaps even pick up transactions that may not be intended to be included. So let's go back to some of the basics. And again, I asked Jonathan and Mitchell to interrupt and jump in anytime they can correct me or say it more clearly or have an insight. So the 2017 Tax Act doubled the basic exclusion amount, the BEA, forgive me. Excuse me. They doubled the basic exclusion amount, the BEA, to $10 million, and leaving aside the inflation adjustment. The doubled portion of the exemption, the additional $5 million that the 2017 Tax Act added, sunsets after 2025. In other words, in 2026, it reverts to the $5 million inflation adjusted that we had before. Some people have estimated that'll be about 6.8 million. I may just use 6.5 because it's easier to say, but with the high inflation rates we're having now, it could be rather significant. Here's an illustration, and thank you and courtesy to Bob Keebler for some of these slides that we've adapted with his permission. This lists what the exemption amounts are. And by the way, what I like about this illustration from Bob Keebler is it shows you the high exemption amounts for these limited number of years in between. And that's exactly why clients want to plan. They want to use that exemption amount before the law changes. And not our topic today because we're sticking to the proposed regs, but a very important topic for us all to talk about is how can we help clients use exemption amounts and secure it, obviously not running afoul of what we now know to be some of the areas the IRS is targeted on artificial or painless gifts before the end of 2025. And I suspect many of us will be quite busy between now and 2025 trying to help clients secure that exemption. We've kind of covered that. Now, just to understand portability and how it relates to all of this. Portability, as you all know, allows the executor to either utilize the decedent's estate tax exclusion, let's just call it 10 million, or to transfer it to the surviving spouse. So if I die and I haven't used any exemption, I don't fund a credit shelter trust, I could give my $10 million exemption to my surviving spouse. A key requirement, which too often people miss, is the requirement to file a federal estate tax return to lock in the portable exemption. And this is important to understand as to what exemptions people will have available. The basic exclusion amount, we used to call the applicable exclusion amount. The BEA, the basic exclusion amount, is the minimum estate tax exclusion amount for a single person. That's the 10 million inflation adjusted, 12,060,000 this year, and it's reduced by prior taxable gifts. The dessous is what you get from a deceased prior spouse, deceased spouse unused exemption. If you've made a gift, so for example, if the current exemption is 12,060,000 and you made a gift of 3,004,000, you have 8.6 million left. All pretty basic. This is, I think, a little helpful to understand how it works in the inflation indexing. So in 2022, if a spouse dies, you get a 12,060,000 dessous, illustrated on the right side of the chart. I have 12,060,000 as well because that's the exemption this year. Next year, there's an inflation adjustment factor that's going to apply and eat 2024 and 2025 to increase the BEA, the basic exclusion amount I have. But note that the dessous is not inflation adjusted. It stays fixed. It doesn't change over time. Now in 2026, the exemption amount drops from 10 million inflation adjusted, the 13.3 illustrated here, to 2026, it's 5 million inflation adjusted or 6,000,008. But if my spouse had died, I still get the same 12,060,000. That doesn't change. So this just helps you understand and see what this all means. Now, in 2019, the final clawback regulations were issued, and the dessous will preserve the doubled exemption if you die before then, and obviously not after that, because then the amount that the deceased spouse can port will be reduced. Now, the basic exclusion amount computations. The credit can't exceed the amount necessary to reduce the gift tax for the calendar year to 0. The dessous is applied to the deceased spouse's gifts before any of the surviving spouse's basic exclusion amount. That's important to understand. So if my spouse died and I'm the surviving spouse and I have a $12 million dessous, I would really like to use up and safeguard my bonus exemption before 2026, because if I don't, that 5 million bonus exemption is going to be gone. But look what I have to do because of the ordering rule highlighted on slide 24. If I want to make a gift of $15 million, that 15 should use up all of my exemption, right? No. I have a dessous of 12,060,000 because my spouse died in 2022. So what I have to do is the first gifts I spend use up my spouse's deceased spouse unused exemption, what ported over to me. So if I make the $15 million gift I said hypothetically a minute ago, that first 12,060,000, call it 12 to make it easier, 12 million uses up my dessous from my deceased spouse, and I've only used 3 million of my exemption. So I haven't even begun to use up my base exemption amount before I can start to eat into or use and secure my bonus exemption amount. So the ordering of how these rules apply is really very significant. Jonathan, do you want to make any comments?
Marty, it's important to know something. Not only do you have to use your spouse's, the inherited exemption you got from your spouse, the dessous, excuse me, before you can use your own exemption. The beauty is that any inherited exemption from your spouse, that dessous, will not be cut back, even if you die when the exemption's gone down. So Marty has a client who died about 1.5 years ago, hadn't used any of her exemption, and her husband inherited her entire dessous. Let's say that was $12 million. That will not be cut back, even if the exemption is cut back to $5 million or $1 million in future years. He will continue to be able to get the $12 million exemption that he's inherited from his wife. And that makes it very, very good to keep it. But again, to use any of his, he would have to use her entire exemption that he inherited now before he gets to use any of his. So in that case, you've got to make some very, very large gifts before the exemption is decreased in 2026 or whenever it happens.
I was just going to add in, guys, there's an example like this in the proposed regs, which make this interesting. Let's say, for example, you've got a surviving spouse who wants to get remarried or is getting remarried or is remarried and wants to lock up the dessous that she has inherited from, say, her first husband. So she wants to do some kind of a transaction to lock it up. Otherwise, if her second spouse predeceases her, she'll lose the first spouse's dessous. So she locks it up. How does she lock it up? Well, could she lock it up with, say, a grit? A grit is not going to work under these regulations, but it will work in the context of a dessous. So the surviving spouse, in my example, could create a grit and thereby lock up the exemption, lock up the dessous, and that exemption won't go away simply because it was a grit. Now, if she did, so after she does the grit, she can then make, say, an outright gift of cash, the reg says, right? And now she can start locking up her own exemption. But what about if she flipped it? What about if she used the cash gift first? She made a cash gift first and then did the grit. Okay, now she's got a problem. That won't work as well, right? So the ordering of the planning is very important here, right? You want to use, if you're trying to lock up the dessous, you want to use, and if you're going to use, say, a promissory note technique or a grit, you want to use that first to lock up the dessous. I'm not sure I made that clear enough. Maybe we can go back to the point.
No, I think you made the point very well. And if we have enough time, which I'm sure we always run out of time, but we have the examples from the proposed regs, and we'll go through all of that again. But what Mitchell did was again emphasize how not intuitive the ordering rule is, how vital the ordering rule is, and how it can have a dramatic change. Mitchell, let me ask you a question, because my understanding of the proposed regs is consistent with what you just said, that these restrictions for these artificial or painless gifts, as we've called them, don't apply to the dessous, so that you can use a promise gift on the dessous, but you can't use it for your own bonus exemption. Is that the correct understanding? Because that seems to be what you just said as well.
Yes, that's what I'm saying, and I think that's true. But I think the ordering is important, as I said, because I think if you first if you first make the cash gift, you use the cash gift, an outright cash gift, to lock up the dessous. And then when you want to try to use your own exemption and you want to use one of these techniques like a grit or a promissory note, it won't work. So, but if you do it in reverse order, if you do the grit first or the promissory note technique first, you've locked up the dessous, and now you can use your cash to make the outright gift and lock up your own personal exemption. So that was my point. That the point was that the ordering of the planning is important here.
Jonathan, let me ask you two questions. Let's say we want to do what Mitchell said, and I want to use up my deceased spouse's dessous with a promise gift. Do you see like a small Dino type problem that if I do the promise gift and then the next day make the cash transfer, do you think there should be some caution to put more time between these things? Does that matter in this context? It seems different than a step transaction.
No, I don't think you have to worry. I don't think there's anything about a step transaction. You'll use the dessous and then you'll take cash and make another gift. In fact, Marty, that's essentially an example in the regulations. So I don't think you have to worry about that at all.
People need to be very careful to make sure they date things properly, because as Mitchell and Jonathan pointed out.
Absolutely. Remember, taxpayers get the lesser of form or substance. So if you've got a bad form, you're going to lose. You've got to have good form as well as real substance to what you do. Let me also mention that a GRIT, which has been mentioned, is a grantor retained income trust. And if you create a grantor retained income trust for yourself, retaining the right to the income as opposed to an annuity as you would with a grantor retained annuity trust, you do not get to subtract the value of the income interest you've retained if the remainder could go to a family member. So maybe you say, well, I'm going to create a GRIT. I'm not going to be able to subtract out any, so I'll use the exemption. Well, that's right. You're not going to use, you're not going to subtract it out. You will use exemption, but that's an asset that's going to be includable back in your estate when you die under Section 2036, which means you've got a double problem. Number one, it's back in your estate, and number two, you do not fall under an exception to the you fall under this exception to the anti-clawback rule, which means you're going to be stuck with the exemption in effect at the time you die.
Let me ask Jonathan, Mitchell, or both, either of you, a question. It seems that the rules for the dessous are much looser, more lenient under the proposed regs than they are for the bonus exemption amount. Do you feel they may change that? Is there a rationale to that I'm not seeing? Why they were gracious for the dessous but not for the bonus? Might they change that because of the planning that we've just talked about, which they seem to acknowledge in the examples?
Can I take a shot at that?
Please.
Okay, so I think that there is something behind the dessous that may account for this. I think there was a concern when the dessous rules came out and the regs initially came out that are we making it more difficult for second spouses to use their exemption? What about if they remarry? They had to take some pressure off of that, right? Because the rule was that if you remarry, you only get the exemption of your last surviving spouse, excuse me, of your last predeceased spouse, right?
Right.
And so that's problematic in terms of getting remarried, right? I mean, if you get remarried, you may wind up forfeiting the dessous. And so I think when they drafted that reg, they tried to take some pressure off of that and say, okay, you can lock up the exemption, you can lock up the dessous rather, even though you're getting remarried, all you have to do is make the gift. And my feeling is they didn't want to take back that in these regs, which would have had the effect of doing so had they come out differently. So I think they were protective of that concept so that they don't get in the way. Otherwise, they'd be getting in the way of remarriage. People would say, hey, you mean if I get remarried, I may lose my exemption? Does the government want to be in that business? I don't think so.
So let me just elaborate for a second. So when we have the exemption in 2026 being cut by half from 10 million inflation adjusted to 5 million inflation adjusted, and somebody has a dessous from a prior spouse and they've remarried, it almost seems like using the exact types of things we've talked about that the proposed regs are restricting for using bonus exemption, like the promise gift, the GRIP, the GRIT. We want to reach out to clients who have a dessous and encourage them to lock it in with, say, a promise gift, because otherwise, if the new spouse dies, not only do they lose the dessous, but they're only going to get a 5 million adjusted exemption for the new spouse. So that kind of second marriage planning becomes even more important, doesn't it?
Not sure. I'm not.
Well, it does. And let me point out something. Again, your spouse dies, you inherit her unused exemption, and then you remarry. You haven't lost the exemption you've inherited from your new from the first spouse that died. The only way you're going to lose it is if your new spouse predeceases you also, and that spouse has a smaller exemption than the first spouse to die. The first spouse you were married to had at the time of his or her death. So one of the things is that you want to make sure if you've inherited a big exemption from the first spouse that died, you ought to think about using it well before your new spouse dies. You don't have to do it before you remarry. It's just that you've got to make sure you've done it, because maybe you're married to someone who's the mother of your children. The lawyer convinces you don't want to use a credit shelter trust, just have the surviving spouse inherit it. So you've now inherited his or her exemption. Let's say it was $10 million. That's great. Then if you get ready to remarry, you may be remarrying someone who has her own family and wants to use her exemption for her own family and not leave it to you as your first spouse did, because you had children of that union, but now you have children of different unions. So you've got to pay attention to what's going on. And if you have a client who's inherited dessous and they're going to get married, you need to, take into account that if the new spouse predeceases them, they're only going to inherit what is unused in the new spouse's estate. Very, very
I think
tricky. And in fact, I think you could make a very good point that when a spouse dies, use the exemption, have it put into a credit shelter trust. And one thing that will permit also is to use the GST exemption of the first spouse to die. Although the exemption can be inherited from the first spouse to die, his or her GST exemption can't be. And I think this concept of portability, my judgment has it's been oversold quite a bit.
this stuff gets very complicated, and the interplay of all of it's very important. Let me just make one last point and then we'll go on, forgive me. But before these proposed regs were issued, I was a little uncertain that a promise gift would be a viable planning technique. It almost seems to me that what the proposed regs are saying is, yes, the promise gift works. And what they're almost saying to me is, because we're giving leniency, and I appreciate, Mitchell, you giving me some logic behind it, because I was trying to struggle to figure out why they're being nice. I didn't expect them to be nice, but it makes sense what you said about not being an impediment to marriage. But it's almost like they're saying now, hey, before these proposed regs, you had no idea that a promise gift would necessarily work. Now we're kind of saying that it works. And given what we've all just talked about for a few minutes now, it almost seems like as soon as you're planning to get remarried, do a promise gift or one of these other techniques and lock in the dessous so you know you don't lose it if your next spouse dies. So it's a little different than the planning that we thought of before.
Well, Marty, let's say I've made a gift by promise of $10 million. And now these regs, if they're adopted in their final form, are going to say, if you die after 2024, we're going to only allow you the smaller exemption. Is there anything that can be done, Marty? I mean, I've already made the gift, but what do I do?
Well, if it's a promise gift, you can pay it off, and we're going to come to that in the 18-month rule. I'm not sure what else you can do to unwind it and get your exemption back, because like I said earlier, you're like in a pickle, you're in limbo. It's like you used your exemption so you can't get it back, but it's, already it's not going to work. You used it, but it's not going to work and you can't get it back. It's kind of a tough situation. Okay, let's go on. So you have the increased exclusion amount, the increased BEA, which was the 5 million that we call bonus exemption that was enacted after in the 2017 Tax Act. But this seems to have an ordering too, that you have to use your base exemption before you can eat into the bonus exemption. So in other words, and Jonathan, I know you've talked about this extensively on prior webinars we've done, where if you make a $5 million gift, you haven't done anything to secure or lock in the bonus exemption before it disappears. You really need to go beyond the base BEA, beyond the 5 million, to start eating into and thereby securing the second tier of it. And just again, everyone, keep in mind, we have the ordering rules that you have to use dessous first. You now have to use your base exemption, the 5 million first, and only then can you eat into the bonus exemption before it expires at the end of 2025. So if your spouse died and you have a $12 million dessous, you have to make a gift of her $12 million dessous or his $12 million dessous plus your base exemption of now about $6,030,000. So you have to make an $18 million gift before you can even begin to eat in and thereby secure your bonus exemption amount. It sounds like GST is not going to be an issue with the change in reduction in exemption after 2025. So if you gave a $12 million gift to a GST exempt trust, yes, if that transfer was made through a mechanism that the proposed regs will attack, I'm not saying this correctly, the GST portion when your exemption declines shouldn't change. So we'd like to think that we're not going to have a problem with by virtue of the reduction in the exemption of that. Jonathan, Mitchell, any comments on how GST is affected by this?
Well, they do not claw back the GST. So if you've used it, you've got it. So maybe what you do is you make a gift by promise of, let's say, $10 million. If you allocate GST exemption to it, but but some reason you've retained an interest or control over it, causing it to come back into your estate, or you made a gift by promise, and they do not claw back the GST exemption, which is kind of interesting. That you could have effectively used the larger exemption, but you can't use the larger basic estate tax and gift tax exclusion.
Let me ask you, because that's kind of a surprising, little bit unusual concept. So if I make a promise gift today to use my exemption because I'm not willing to part with money, and I file a gift tax return and not only show that I'm using up exemption, but I also allocate GST to it, so that I'll face an estate tax, but it sounds like that's an effective plan to lock in GST exemption. So if I really don't ever want to make this gift while I'm alive, the promise can still lock in my GST, even though it doesn't lock in my basic exclusion or bonus exemption amount?
It seems that way to me. Mitchell, what do you think?
I do read it that way. I think the slide that you've got up here seems to indicate that they feel that the statute doesn't permit them to take back the GST exemption. Isn't that what it seems to be suggesting?
That's what I think.
Yeah, I think that they feel uncomfortable trying to stretch the statute to do this.
Let me also mention one thing here. If you have an extremely wealthy client, let's say someone with a couple of $100 million, that client can use the exemption, just make a completed gift. In fact, if they want to retain an interest with not having it come back, create a spousal lifetime access trust for your spouse, keeping in mind that unlike a marital deduction trust, you don't have to put your spouse in by name. You can just say, this is a trust for the benefit of my spouse, whoever that may be at the time in question, and my descendants. And you can give your spouse a power to appoint the property back to you. And assuming there's no sort of understanding where they'd say, if you get it back, it's going to be in your estate, you've now made a completed gift. You can allocate GST exemption to it, and there will be no clawback. If you've got, say more than $100 million, why not do that?
So let's go through some of the examples and talk about what they mean. So example one, individual makes a cumulative gift of 9 million, all of which is sheltered by tax because their basic exclusion amount or BEA is 11.4 million. So the exclusion amount now drops. The person dies after 2025, in other words, 2026 or later. So the exemption at death is only 6.8 million. The credit against the tax is 9 million. Why? Because they made a completed gift of 9 million, and the exemption for that completed gift is locked in. It's not clawed back. So their exemption that's applied against the tax cost is 9 million. Yes, they've still lost 2.4 million because they didn't use all of their bonus exemption. But what this says is once you eat into part of the bonus exemption strata, the level of bonus exemption, whatever you eat into and use and secure through a completed gift, that works. Any comment, Jonathan? Mitch?
Well, I think that's right, Marty.
Now let's take a look at the second example. You make cumulative gifts of 4 million. They're all sheltered by your exemption, which is 11.4. And adjusted taxable gifts are included in the estate tax computation. The exemption at death is 6.8 million. That's 5 million inflation adjusted. We're assuming 6.8. The credit against the tax is the 6.8. So in other words, you've made gifts today, but not enough to eat into that bonus exemption level. So you've only used into the first 5 million. You haven't really eaten beyond that. So when you die, you get the lesser of the secured gift exemption when you made gifts while you were alive before 2026 when the exemption's higher, or what you have at death. In this case, because they haven't eaten into it, you have a lower exemption. Now, this shows that if you don't eat into that beyond the layer of your basic exclusion amount, the BEA of the 5 million inflation adjusted, you've secured nothing. So a lot of the planning that some people have done, and we've all seen this, where they'll give, they plan like non-reciprocal slats, and then they each give 4 million to the non-reciprocal slats. They've accomplished nothing to preserve any of their bonus exemption. And Jonathan, I know you've emphasized this point many times when we were talking in 2020 and 2021. You got to get into the higher amounts, or you're not really salvaging anything. And that's in effect what this is saying.
Let me mention what happens when you die and you have an exemption. Let's say you're going to have the exemption. It doesn't go down. It's going to be today 10 million inflation adjusted. Doesn't matter whether you use it or not. And again, it's not a double use because they bring your adjusted taxable gifts back in. What they do is they apply the exemption first against the gifts you've made during lifetime. So if you say, well, all right, I have a $12 million exemption, I think I can afford to give away, and I don't think it'll ever be below 5 million. So I'm going to give away $7 million. So you give away 7 million and you think you've secured 5, you haven't. Because when you die, they're going to apply the then exemption first against exemption you've used during your lifetime. It's very, very tough for upper middle class people. For the super wealthy, they don't have to worry about, but for the just rich, it is a real problem.
And I would add to that not only is it a real problem, as Jonathan says, but I would suspect a lot of clients don't understand this. They may have set up irrevocable trusts, made gifts of $3, $4, $5 million, and not understand that they've not accomplished anything. I mean, they have, because the growth in their estate, especially with recent stock market performance, gets all that growth out of their estate, right, Mitchell?
Yes, Marty.
So
Yes.
that's a joke.
Except we
not had a lot of growth
lately, Marty. We haven't had a lot of growth. We've had decline.
Yeah, so they've locked in. They've done reverse estate planning.
Yeah, yeah. We can all cry together about that.
Locked in higher values.
We can all cry together about that with our clients. Example 3, spouse dies before 2026. So now we're in a dessous situation. Elects portability when the BEA, the basic exclusion amount, is 11.4. The first spouse to die made no taxable gifts and didn't have a taxable estate. So the full amount of the exemption gets ported because there's no taxable gifts, no reduction. The surviving spouse makes no taxable gifts and doesn't remarry prior to dying. So a very simplified example, when the surviving spouse dies, the exemption is 6.8. That's the 5 million inflation adjusted. How much exemption does the surviving spouse get on their death? Well, you have the 11.4, which is the dessous, and we illustrated that multiple ways earlier. Plus, they have the 6.8 million basic exclusion amount, which is the exemption amount in 2026 or later, when it's 5 million inflation adjusted after the reduction. So this shows you how it's worked. The deceased spouse's dessous is preserved, but the surviving spouse's doubled exemption is lost. And keep in mind, everybody, the examples and the detail that we discussed earlier, that if this person is going to remarry, they very well may want to make a promise gift, because the regs seem to say that's okay, or a grip or a grit to lock in the 11.4, because if they remarry, the new spouse's exemption is only 6.8, and as Jonathan astutely pointed out, the new spouse may want to use that for his or her descendants and not for this taxpayer's descendants. So keep that in mind as well. Example 4, spouse dies before 2026 and elects portability when the BEA is 11.4. First spouse made no taxable gifts, didn't have a taxable estate. So it's the same concept, and the full amount of 11.4 is ported. The surviving spouse makes 14 million of gifts, and this is the concept that we had discussed earlier. And what happens is the dessous has to be used first. So the 14 million of gift that was made first uses up the 11.4 of portable exemption, the dessous, and only after that uses some of the basic exclusion amount. So what we're going to see is the surviving spouse only used the differential of 14 minus 11.4 of basic exclusion amount. They didn't eat into or preserve any of the bonus exemption that they had with the gift. So the surviving spouse doesn't remarry, and then they die when the BEA, the basic exclusion, is 6.8. So after 2025, it drops by half, and it's 6.8. The credit against the estate tax is based on 8.2 million. The 11.4, so the dessous is used, 6.8, and the 14 million a gift is included in the estate. So again, they've preserved the dessous. They haven't locked in any of their bonus exemption in the example. Now, let's talk about in more detail. We've covered some of this, so parts of this we'll go through quickly. And forgive me, it's my fault that I got us sidetracked a little earlier, but I didn't intentionally, because in talking to brilliant people like Jonathan and Mitchell, there's just ideas that come to mind, and I thought we addressed some very interesting issues earlier. So forgive me that it was a little out of order, but I just thought it was very valuable and I didn't want to lose it. So again, the concept that we talked about earlier is Treasury was in particular concerned about painless or artificial gifts, where you've kept the income interest or you've kept access to the assets, but you've made a completed gift. And it's interesting because Jonathan is correct. It sounds like a gift to a spousal lifetime access trust or even a self-settled trust where you're a discretionary beneficiary in the hands of an independent institutional trust or institutional trustee. Those you still have access to, but those aren't really being deemed artificial or painless gifts. So we talked about the grit, where you give a family member the remainder, you keep an income interest. The value of the retained interest is valued at zero because it's not a qualified interest. If it were to somebody that didn't qualify as family as defined in the regs, it would be a qualified interest. You'd have the subtraction method apply, but it wasn't. So you think you used up all your exemption. Similarly with a preferred partnership, if you don't have the value of the structure of a qualified interest, the subtraction method puts a zero value on the retained interest, and the full amount is deemed a gift. So in both of those instances, you retain rights to the economics of what you've transferred, but used up a bigger chunk of the exemption, and that's something that they're trying to take a look at. Now, the enforceable promise is a third area, and we've talked about that. We've talked about the 2036, 2038, 2042, and some of the other provisions where you have a gift, but it's included in the estate. One of the other things that seems to be also brought in is a Q-tip. Let me explain the planning concept and then let Mitchell and Jonathan elaborate. So if you have a spouse, first spouse died, surviving spouse has assets in a Q-tip trust. Let's say there's $10 million in this Q-tip. It may be very uncomfortable or difficult for the surviving spouse, and assume there's no dessous because the surviving spouse funded a credit shelter and used up whatever his or her exemption was. It's very hard for the surviving spouse in many examples, and Jonathan really hit the nail on the head. The super wealthy have no problem. They just make the transfer, lock in the exemption. But it's the merely rich that have a difficult problem. So if spouse died, funded a credit shelter, and the balance went into a Q-tip to avoid any estate tax on first death, the surviving spouse may be uncomfortable giving up any of his or her assets, especially enough to use up his or her BEA and then start to break into or use up all of the bonus exemption. But they may be more comfortable doing it with the Q-tip. Why? Because the Q-tip isn't really, they don't see the bank account in their name, it's in the Q-tip trust's name. So they may be more comfortable making a gift with the Q-tip. Under Code Section 2519, if the surviving spouse gives up any portion of the income interest in the Q-tip, 1% for argument's sake, it's deemed under Code Section 2519 to be a transfer of the entirety of the corpus of the Q-tip. So if in my example, there's a $10 million Q-tip and they give up 1% of it, it's deemed that they made a $10 million gift and use up $10 million of their current exemption amount, which not only uses up all of the BEA of the surviving spouse, but eats well into most of the bonus exemption amount, thereby preserving it. Now, That's a planning technique many people use because it's just more comfortable for a surviving spouse to do. What I believe they're saying in the proposed regs is that if you use this technique because you've still retained 99% of the income interest, for example, that is going to be one of those painless transactions that they're not going to respect as having used and secured your bonus exemption. Jonathan, Mitchell, any comments?
Yeah, well, let me just point it out. When the surviving spouse makes a gift of part of his or her income interest, she or he is deemed to have made a gift to the entire remainder, but they retain their income interest. But if the remainder beneficiaries of that trust could be members of the family, then that means that Section 2702 is going to apply. That means there'll be no value subscribed to that retained income interest. So that surviving spouse will be deemed to have made a gift of the whole. But as Marty says, because she or he will have retained an income interest in the Q-tip trust, it means it's going to come back and hit the anti-clawback exception, meaning they will be deemed to have their exemption clawed back if they die after 2025.
I would just
Can I
add,
ask? Sure.
I was just going to add to what Jonathan's saying. I think it's implicit in what he was saying, is I think the key there is that 2036 is going to apply, right, Jonathan? 2036 is going to apply.
That's what, when Mitchell and I first heard about people saying, well, what we're going to do is we'll create, Mitchell will create a Q-tip trust for his wife. She'll give away $1 of the income and there'll be a gift and it's all going to be used and there's no problem. Well, Mitchell and I thought about it and we concluded, this goes back, Mitchell, to 2010. There would be a 2036 issue for the surviving spouse. And I think those who felt otherwise have now agreed that we were probably right on that.
Yes, and so these new regs would say that because 2036 applies when the surviving spouse dies, you can't get the benefit of the exemption. You're going to lose what Marty's calling the bonus exemption here, right? It's not going to work to lock up the exemption because of the 2036 inclusion.
At least we don't think it will. We don't think it will, and that's important for your clients to know because, somebody comes in, they've got $30 million worth of property, $50 million worth of property, and they say, I want to use this exemption, but I can't afford to give up the property. Well, don't accept the lawyer saying, well, just do a Q-tip trust for your spouse, and he can give away a portion of his income interest. He'll basically have it all, and you'll have used your exemption. Yes, you will have used exemption, but it's going to be clawed back because an exception to the anti-clawback rule applies where someone has made a transfer with a retained income interest, which we believe happens where you give away $1 worth of your income interest in a Q-tip trust.
So here's my question on this hypo. Let's say that you're talking to a client who's done this, right? Who's last year, they did one of these Q-tips and now they want to know what to do. Okay, so they thought they locked up the exemption by doing the Q-tip, but under these regs, that plan will fail. So the surviving spouse could, I suppose, right, give up his or her income interest, his or her remaining income interest, and live for some period of time. Now, I say for some period of time because the question I'm going to ask is, does the surviving spouse have to live for 3 years to avoid 2035? Or can the surviving spouse live for 18 months and qualify under this 18-month rule in the regulation? I suspect it's 3 years, but I do think that they muddied it up a bit with that 18-month rule, and I think they need to clarify it.
Well, let's tell everybody what the 18-month rule is, Marty.
Before we come to that, let me just, forgive me, Jonathan, and we have slides. We're going to come to that in a minute. Mitchell, Jonathan, if I gave up the only reason that you have an inclusion potentially under 2036 is because I've retained the income interest in this asset, correct?
Correct.
So yes. If I give up all of my income interest in the Q-tip, then I shouldn't have an issue of 2036 inclusion, and my use of this plan should not be a problem under the proposed regs. Is that correct?
Well, no, I think, if we put aside these regs, right, just let's talk about traditional estate tax rules. Under the traditional understanding of 2036, if I, as you said, Marty, if I create a trust and I retain the right to income for the rest of my life, obviously if I die while the income interest is still intact, it's includable in my estate under 2036. If I give it away, if I give the income interest away one day before my death on my deathbed, 2036 is off the table because that's the peculiar way in which 2036 is worded. Okay, so 2036 is off the table, but in rides 2035 to the IRS's rescue and says, if you did anything like that within 3 years of death, we're going to bring it back in under 2035, right? So now you get these new rules, and the question is, if I give it away, you know, how long do I have to live after I give it away? Does this 2035 3-year rule still apply? I think it does, but there is an 18-month rule in there that's kind of interesting that needs to be explored.
We're going to come to the 18-month rule, but forgive me, and maybe I'm a little slower than both of you. Probably am. I am for sure. If husband dies and sets up a Q-tip for wife then decides in 2021 or 2022, anytime before the end of 2025, she wants to give up the income interest in order to secure the exemption amount that she has. There's no dissue, so that's not relevant based on the examples from the proposed regs. I understand if she gives up 1%, that she's retained 99% and it's included. What if she relinquishes 100% of the income interest in the Q-tip? Does that now stand so that she's not subject to clawback because she gave up all of the income interest, leaving aside the 18-month and 3-year question?
I think that's the answer, don't you, Jonathan? There is no, if you give it up, and assuming you live the requisite period of time, let's say it's 3 years, then there can be no 2036 application, there can be no 2035 application, and these new regs require inclusion in the gross estate under one of those sections if you don't have a promissory gift technique or the what you call the grip, right? These new regs say that once you're out of the scope of 2036 and 2035, once you're out of the scope of estate tax inclusion, you got it. You got your exemption locked up.
So it sounds like using a relinquishment of an income interest under 2519 can be a valid way to lock in exemption, but the distinction is if you do it, you can't just give up $1. I think Jonathan used as an example, or 1% on slide 33. You have to give up the entirety of the income interest to avoid the 2036 string.
Well, let's say you gave up half of the income interest. Okay, then I think you still have a 2036 inclusion, probably with respect to half of it.
I agree.
I was understanding it differently, that if you gave up anything but all of it, you may have a 2036 issue. And the solution to that seems simple. And there's several private letter rulings saying how you can divide a Q-tip and do a disclaimer on part and not the other part. So if you only wanted to give up half the income interest, why don't you divide the Q-tip, relinquish 100% of the income interest on one part, and then that part should suffice to not be caught by these anti-clawback regs, the new proposed regs. So you've gotten that piece out and used exemption and locked in the exemption to the extent you're comfortable.
I think that's plausible, don't you, Jonathan? Of course, you're not. Of course, the question is how much exemption have you locked up, right? You know, if you're only dealing with half, then you've locked up half.
Let me ask one last question, if I may. So many Q-tips, not all by any means, but many Q-tips will give the surviving spouse or the independent trustee principal invasion rights. So why be a pig about it? Why be greedy instead of disclaiming 1% or 5% or $1 of the income interest? I'll disclaim the whole income interest because the independent trustee can still make principal distributions to me as the surviving spouse, and therefore I've still got access to the whole trust, but I think I'm outside of these proposed regs.
Well, you're back into a 2036 question, right? And the issue
How
there,
so?
What, Marty?
How am I in 2036?
Well, you're into what I said was a 2036 question, right?
Oh, okay.
If you give up the income interest, but there's an implied understanding that the trustee will make invasions for your benefit, then you still have a 2036A1 inclusion. right? So now you've got a fact question as to whether or not there was an implied understanding.
Right, very good, yes. But I think we've just given people some interesting planning ideas. And I love your thought of, if you only gave away 1%, do you go back and give away the remaining income interest? And we'll come in a minute to the 3-year versus 18-month rules. And I hope one of you two scholars can enlighten me on it, because I find it very confusing which one we're applying when. But I think we've just given the audience some interesting planning ideas with Q-tips. I think we can skip through this because we've kind of talked about this. It's just the regs and highlighted. But let's get into some of the details. So we've already talked about it, but maybe slide 37 will help summarize it for everybody, the things we've talked about. Gifts within 3 years of death, life estates under 2036, certain transfers taking effect at death under 2037, revocable transfers under 2038, life insurance, Jonathan mentioned that, under 2042, enforceable promises, freeze partnerships under 2701, grats and grits and cuprits, rather grats and cuprits under 2702. And we have to talk about that, time permitting, because if you outlive the grat or cuprit term, I think you're fine. But if you die within the middle, it's a different issue. And then transfers within 18 months. By the way,
of death, Jonathan has made this point before. Marty, Jonathan has made this point before, so I think it's worthwhile making. That first item on the list, gifts within 3 years of death, and then 2035 is cited. I think that's a little fluky, in that I think that I could, the day before my death, make a gift, an outright gift, and thereby lock up the exemption, right? Because 2035 doesn't apply to outright gifts like that. So I think that's worthwhile mentioning.
No, very good point. Thank you.
Well, again, you're going to have to do it while the exemption is enlarged. So, you know, you're going to have to figure out, well, remember, if you make a $12 million gift today and you die before 2026, you don't have to worry about any clawback of the exemption, because the exemption, barring a change in the law, is going to be, you know, 12 million when you die. So it would be very, very strange that, you know, someone would use an exemption just before she dies, the last day of 2025, and then dies in 2026. It's not going to happen.
No,
like
but I guess it could happen. I guess it could happen. You could make a gift in 2025 and die in 2027, and still lock up the exemption, even though you're within the 3-year period. So I guess that could happen, more likely. But I agree.
Would one of you gentlemen like to explain what happens if you relinquish some of these rights within 18 months of dying? Because then we can talk about the flip side of it.
Yeah, they say that you can give up, let's say you do a grit. You've done a trust in which you retain the income interest. It's going to be in your estate under 2036, and you're going to have it clawed back if you die after 2025. But they said, if you give it up more than 18 months prior to your death, it doesn't matter whether it's in your estate or not, we will not cut back, we will not claw back the exemption used. So you've got to, again, if you die before 2026, you don't have to worry about this at all. So this is something that you need to be aware of. But if your client says, I've got to have the income interest, and the client gets sick, now it's after 2025, and you say, well, look, why don't you give it up? And if you live for 18 months, we will preserve the exemption. I don't think, I think it's going to be rare for that to become a real issue for most people.
Now, if I recall correctly, I don't think the example, the grid example in the reg, deals with giving it up before death, does it? I don't think it does.
No, it talks about it terminating, because if you give it up, well, I think, Mitchell, it may cover you give it up or someone takes it away from you.
Yes.
Because if you give it up, you're going to fall under the 2035.
Right. I think this is the place, Jonathan, I think we agree. This is the place where it gets a little fuzzy in terms of whether the 3-year rule or the 18-month rule applies, don't you think?
I do.
And I think they could use an example in the regs that would clarify what they meant by this. Now, I think the 18-month rule, I think, is well illustrated with a promissory note, right? I have a promissory note outstanding that I gifted it some time ago, and now I want to get rid of this problem, right? I want to be able to make sure my exemption is secure, my extra exemption is secure, so I repay it. And I think that if I repay it, and I do it with, more than 18 months before my death, I think I'm okay. I think that's what they probably had in mind. I wonder, is there any argument that maybe the note is includable, the assets with respect to the note, or the note is includable in my estate under some other section like 2036, which could take us over to 2035 and the 3-year rule? I mean, I think that's interesting. I went back and looked at Revenue Ruling 84-25, which is the promissory note, where the promissory note technique comes from, Rev Rule 84-25, and it's cited in this preamble. And to my surprise, because I didn't remember it this way, they do not make clear why it's includable in the gross estate. They never cite 2033 or 2036. They don't tell us their theory of inclusion as I read it currently, recently. So, I don't know. I don't even know there. I think that the 18-month rule applies with respect to the promissory note, but I'm not even 100% certain there.
Wow.
But it does make for an
So-
interesting plan, doesn't it? Don't you think? I mean, you guys are the planners. I'm just the academic here. But it does make for interesting planning, I think, that I can give a promissory note today and have it outstanding, not pay it. And then some point in the future, maybe in 2028, I decide, hey, I really want to make this note work in terms of locking up the exemption. If I can repay it now and live for 18 months, I've got it. So I think it's kind of an interesting way to do something without really doing something, giving yourself some optionality.
Well, keep in mind that if you're going to do this, I mean, you've done it to begin with because you didn't want to give up the assets. So you're going to have to be in a position where you're going to live for 18 months after you pay off the note. But you're confident you're not going to live that much longer, or maybe your wealth is increased. But if your wealth is increased, why not pay it off at any time? Also, keep in mind that the gift by promise raises some interesting issues. If I make an enforceable promise today to Marty to give him $10 million before I die, what is that promise worth today? Well, I'm not that old. I may have 15 or 20 years to live. What's the right to receive $12 million 15 or 20 years from now? Well, it's not worth $12 million today, that's for sure. So do you have to add interest on it? And what kind of interest do you have to add so that the gift today is the full $12 million? And I think if you say, well, okay, Marty, I'm going to pay this off, the $12 million, and I'm going to pay you AFR interest, I don't think that will mean it's worth $12 million. Even though I put AFR interest on it, I don't think that's going to make the note whole at this time. So using these notes, the promise by gift is complicated to begin with. And then when you get to the point, well, I'm going to pay it off more than 18 months before I die, but I won't have to worry about it because I'm so old, or I'm going to die soon thereafter. Very, very dicey. I'm not sure that the service gave much away under this 18-month rule.
Hey, Mitchell.
Jonathan, you've also made the point to me previously that I think is interesting, and I don't know the answer to it. What are the income tax consequences to the donee when they receive the note, when they receive the payment on the note? Do they have income?
Right.
I mean, I think it's probably a gift that's excludable under 102, at least with respect to the principal. But we don't have any authority on point that makes that clear.
Very interesting.
Well, if you do this, you better do it with a grantor trust. That way,
But
at least under current law, there wouldn't be any consequences to it. But it's not as easy as slipping off a greasy log. That is for sure. It's going to have to be served. And do you have to pay the interest? Can you let the interest accrue? Of course, the IRS very often uses the failure to pay interest as evidence that it wasn't really intended to be enforced. Now, maybe if you've reported it on a gift tax return, you win. But, the service almost certainly is not going to come back to you and say, well, you said you made a gift, but we're going to take the position you really didn't make a gift. Very, very complicated stuff.
Let me share with both of you and the audience a sort of a spin on this that Bob Keebler, to give him credit for, suggested that I thought was kind of interesting, and hear what you have to say. You know, as you get near the end of 2025, if people aren't using up their exemption, it's the bonus exemption, they're going to lose it thereafter. So let's say you have somebody in their early 60s, they're not retired, they're still working. You know, they're very well afraid of making a large transfer in their early 60s because they don't know what's going to happen with the stock market. Take a look at what's going on in the markets. They're not sure how expensive retirement will be or healthcare costs and so on and so forth. But if they make a gift of a promise before the end of 2025, theoretically, they may be able to lock in their exemption. And what do they do about the 18-year rule, the 18-month rule? So, you know, at age 65, 62, I mean, their life expectancy could be 20, 25 years, joint life, you know, quite some time. So what if they make the gift of the promise before the end of 2025 to lock in their exemption? And then in 10 or 15 years at age 75, you know, they still have statistically a good number of years to go. They should make it to 75. Obviously, some won't, but the odds are the vast majority will. They reassess, do some new financial modeling, some new Monte Carlo simulations based on a then current budget, and maybe then they can pay off part of the note or all of the note. Does that seem to make sense as a pre-2026 planning strategy, like a Hail Mary just to lock in the exemption? Why not?
Well, you know, Marty, one of the things is that there is a very, very good chance that there will be a run again to eliminate the ignoring of grantor trusts. That's been on every significant proposal made by the Democrats. And as you're aware, a letter was written some months ago by Representative Pasquale of New Jersey, who is a member of the House Ways and Means Committee, to Janet Yellen, the head of the Fed, saying you need to do something about this. You need to get rid of this ability to deal with a grantor trust without any income tax effect. And it's even possible the IRS could do it by revoking Revenue Ruling 85-13. So to say, you know, we got plenty of time, you know, we'll make that gift now, but we could pay it off. Because if it is a gift when you pay it off, because, you know, it's a grant or a trust, you're going to have a problem. Keep in mind, this is different than the gift you made. Now it's paying off the obligation, which may not, Mitchell, I think, necessarily come under Section 101 of the code, which excludes gifts, bequests, and inheritances from gross income.
Yeah, I would just, for the audience, I would just throw out two authorities that they might want to look at in assessing this kind of a gift by promissory note technique. So there's one case in the Second Circuit called Flandreau, which denied a 2053 deduction for the note that was still existing at the time of death. So that's one shot that the IRS might take to deny the 2053 deduction if the note is not repaid. Of course, we're talking about repaying the note. The other one is Revenue Ruling 77-299, which refers to the concept Jonathan was alluding to before, and that is, was there a true intent to repay this note? Because if there was no true intent to have this to be a real note, then maybe it wasn't a gift in the first place, and you don't get to lock up the exemption. So I think those would be two authorities to take a look at if you're interested in this in this technique.
Let me throw one last comment, thought, question to all of you. And Jonathan, I know you wrote an article some years ago on, I believe I forgot exactly what the title of the article was, but on restructuring notes to lower the interest rate. And I think you maintained in the article that there's no gift or income tax consequence to renegotiating a note when there's no prohibition on prepayment. Do you remember where that was published, in case anyone wants to find it, or what the exact title was?
Yeah, it was published. It was published in the July either 2007 or 2008 issue of the Journal of Taxation, and it was by Bridget Crawford, Lisi Madden, and me. And it's entitled "How Low Can You Go?" So if you just put in you know, Blotmacher or Crawford or Madden and how low can you go in the Journal of Taxation, you'll find it. It's one of my grandmother's favorite articles, by the way.
So question, Jonathan, since you're the authority on the point. Let's say I did a promise gift in 2025 and I did it for $13 million, 13.3, because that's what the exemption is guesstimated to be, whatever the exemption amount is then, because I want to use it all up. And then I use the Keebler approach. I can't repay it now. I'm just going into retirement. 10 years from now, I reassess and say, boy, I'm doing okay. I think I can repay 7 million of it. So I'll use up some of my bonus. I'll use up my BEA, my base exemption, and start eating into my bonus exemption a little bit, and then I'll reassess in a few years. Can I divide the note, repay 7 million? So if it's a $13 million note, make a 7 million and a 6 million, repay the 7 and let the 6 go on in case I in the future feel comfortable repaying it. Thoughts about that type of planning? Because if that works, it gives us a lot more flexibility to let clients be comfortable paying down the note because we don't know when we're going to die. We want to be more than 18 months before death. But if I can break the $13 million note up into 13 separate notes and repay them every time I feel comfortable doing it, I'm a lot better off. Any thoughts?
Well, that's an interesting idea, Marty, because you will have used, in theory, you used your whole exemption, and now the only part that would be clawed back would be that $6 million remaining note. But what do you think, Mitchell? I'm not sure you get much of an advantage of doing that.
But
No, yeah.
that...
Go ahead, Marty.
No, I was just saying, but if I repay 7 million and I only have 6 outstanding, and then I die 19 months later, the 7 million note that I repaid is not subject to clawback. I've locked in at least a piece of the bonus exemption. And if I break it, like I said in the second hypothetical, into 13 separate $1 million notes, if I paid off 8 or 9 of those, then 8 or 9 million shouldn't be clawed back as long as they're more than 18 months before I die, because we don't know when we're going to die, absent having a Ouija board. It lets me kind of hedge my bets.
I'm not sure. I want to think about this. I'm not sure it works as a practical matter, because I think for most people, they're going to want to make sure the note works in its entirety, right? Because if you were trying to capture the exemption, if you're only going to repay, say, 6 million of the note, and the exemption when in the year of my death is, say, 6.8 anyway, I haven't accomplished much. So as a practical matter, I'm not sure where it goes. But the other thought that does occur to me is I wonder if you start trying to dice it up that way, if you start making the IRS's revenue ruling 77-299 argument more powerful. In other words, does it look like it's now more tax driven and that truly there was no real intent to repay? I'm just wondering how it plays in those terms. I don't know. That's what I would be concerned about.
Okay, lots of food for thought for everybody. I think when these regs are finalized, assuming they're going to be finalized, we all have a lot of stuff to have to think about. There are some exceptions. Sure.
Marty, I'm going to ask Mitchell to comment on this because he's the real expert here. Mitchell, what do you think the chances are of the Treasury coming out with regulations which are tougher than what we have right now? For example, as Marty pointed out at the beginning, you could do a self-settled trust, and you do it in a jurisdiction like Alaska or Delaware where your creditors can't get it. You will have made a gift, and yet you're a beneficiary for the rest of your life. And it's not going to be includable in your estate under 2036 or otherwise. So, you do that. Are you really getting much further by what we have been discussing here on it? I just don't know, because of the the clawback. But Marty, go through these two exceptions if you would, please.
So one exception we've kind of talked about in the reverse. I don't know if that's the right language, but if you die within 18 months, paying off the note 17 months before you die is not going to help. But the converse of that is that, or the flip side of that, is that if you pay off the notes 19 months before you die, you've locked in your exemption. So that becomes an exception to the exceptions provided in the proposed regs, so that you will still get the benefit of the anti-clawback regs. You'll keep your higher exemption. The other exemption is where the transfer is 5% or less of the value of the transfer. So in other words, typical grantor retained annuity trust, GRATs, you put in $1 million. Usually when you do a GRAT, some people zero them out, the Walton regs. I've always felt you should have some dollar value to the GRAT, whether it's $100, $1,000. And Jonathan, I think you have some concept about a 0.1%, some minimum amount of value. I always like some value because I'm not quite clear what I'm getting when I report a zero value on a gift tax return. If I have even $1 of value or $1,000 of value, I can report the gift and toll the statute of limitations. Most GRATs were structured with 5% or less of the value of the transfer. So those are not caught up in the things the proposed regs we're trying to get at. Conceptually, where you're making a transfer where you kind of structured, and I forgive the use of the word, this may be inappropriate, forgive me, distorted the planning to use up more exemption, that's what they're kind of getting at. So they gave a de minimis amount, but it's very low, that if the amount is quite small relative to the principal value of the transfer, they're not worried about these artificial or painless gift concepts. Mitchell or Jonathan, we'll have some examples in the proposed regs we'll go through, but do either of you want to comment on these? So if you relinquish or eliminate any interest in one of the exceptions provided more than 18 months before death, you seem to have solved the problem. Mitchell raised a very interesting point, which is the interplay of the 3-year rule under 2035 and the 18-month period. Code section 2035 provides that if a decedent made a transfer by trust or otherwise of an interest in any property or relinquished a power with respect to any property during the 3-year period ending on death, then those transfers could be pulled back into the estate. But it seems that 2035 requires some affirmative transfer or relinquishment by the taxpayer. And in contrast, and I think this was some comments I gleaned from some comments made by Austin Bramwell in a presentation he gave, and my humble apologies if I messed up everything that Austin said, because he's obviously brilliant and gave a very scholarly presentation on this. But it seems like the proposed regs are broader, so that it's not just an affirmative transfer or relinquishment by the taxpayer, but any elimination of an interest, power, or property within the 18 months, whether by the decedent alone or conjunction with another person, would be caught up. So in other words, it's a broader net, but for half the period of time. And I don't remember if it was Stacy Eastland who made some interesting comments about this, or Austin, but it sounds like the IRS is saying that we're going to take a broader approach, but limit it to 18 months. This way, they don't have to get into the argument if you gave somebody else a power to terminate your right, and that's what did it, you won't be caught in 2035, but you will be caught by the 18-month rule. Mitchell, Jonathan, do you want to elaborate or make what I said more sensible?
Well, I think you stated it correctly.
I would just add, I think what they're doing with all of this language about how the string, if you will, gets terminated or relinquished or with the consent of somebody else, I think this is probably a position that they would take under existing law in the context of 2035. And they're just writing into the regulation this language for this purpose. But it's the approach they would take under current law, I think, with respect to 2035 is my sense. There's a TAM, which kind of, I think it's about 20 years old now, which kind of takes this position under 2035, as I recall.
Interesting. Can I ask either or both of you a question? If I recall, and forgive me to Stacy Eastland if I misunderstood his comment, but Stacy suggested that inherent in this comment, in these proposed regs, in this rule that they're proposing, is an acknowledgement that there's limitations on the Powell or Moore concept. Can either of you explain or elaborate on that? What he might have meant?
I'm not at all sure. Do you know, Mitchell, or can you speculate, Mitchell?
I'm not sure. Do you think, Marty, it had something to do with this language we're talking about in terms of the ability to relinquish or eliminate or with someone else's consent?
Yeah, I think that's where he was going, but I didn't quite follow it, and it was a very quick comment, but it sounded kind of interesting, and I wish he had had more time to elaborate. I don't think he.
I mean, I'm speculating here, so I'm out on a limb, but it seems to me that one could think about the Powell concept of being able, for example, to modify or to liquidate the partnership by acting in conjunction with other limited partners. In some sense, I could see an analogy to that concept in terms of this language, don't you think?
Right, but I think the point is that because they actually made this explicit in the regulation, it means that the Powell case alone wouldn't bring it in, and maybe that gives us some comfort in areas that aren't affected by the proposed regulation. In other words, that because they had to be expressed here, elsewhere, it means it may not in fact be covered, and they're acknowledging the Treasury is acknowledging the limitations on Powell.
Marty, I think we're about out of time. So unless you have something extra to add, I think we can wrap up.
I think there's one last point, and I think that I would ask you and Mitchell to just comment because I think it's very important. So what do we do as practitioners? What I've suggested, and you guys may have different views, but please share them, is I think we need to communicate to clients that these proposed regs are out there. They may affect prior planning. And I think as came out from here, which I hadn't realized before, is you may be as a client in a pickle where you used exemption, but it's not going to be preserved from the clawback. I think we need to tell clients that it's out there. I think a general newsletter is fine, or communication is fine. I'm not saying it's a standard or practice required, but I think it's worth doing. If the regs are finalized, let's say in identical form, I think we need to tell clients, if you've done one of these transactions, you need to call us so we can try to see what else you can do, whether it's paying off a note before the 18 months before you die, or so on and so forth. What do you suggest practitioners do with all this?
Well, I think there's very little to think about right now. The only thing I think you might be able to get away with is you create a trust, for example, where you created a trust, for your spouse, and you fund it with assets, and then you buy the assets back from the trust. Maybe it's a grantor trust, so there's no gain. And maybe you've defeated this exception to the anti-clawback rule because it's not a trust for you, it's a trust for your spouse. That does not appear to be caught by these regulations, and I think that maybe that's the way people will do this. You get to keep the assets because you'll buy them back for a note. Now, again, you have to worry about what the service will argue. This was all wired, it's not real, it's not a real note, you never intended to pay it off. But that does not, at least directly, appear to be covered by these proposed regulations.
I would just say, Marty, I like Jonathan's slat idea. I think that's a good one. Putting aside for a moment his technique with the putting in an asset and buying it back with a note. But I think the slat is in all likelihood not going to be covered in the final regulations. But one word of caution as we wrap up, maybe planning should be put on hold for a little bit until we see what the final regs do look like.
Wow. So you think there's a chance that slats or self-settled?
No, I'm not saying that. I'm not saying that. I mean, I think Jonathan and I discussed this earlier, actually today. Jonathan made the point, and I agree with him, that if they try to expand it to slats, they probably would have to issue proposed regulations all over again and start the comment period all over again. There are some recent cases out there where the courts are enforcing the Administrative Procedure Act very aggressively against the IRS. So, for example, regulations have recently been invalidated by one of the circuit courts because the IRS didn't respond to a significant question that a commenter had raised. So I think they'll be very cautious about the APA, and I don't think they would come in with something radically different without reproposing. But nonetheless, unless there's an urgency to get this done immediately, it might make sense to wait until we see what the final regs look like.
I would certainly hope that they don't do what you said, because if they try to subject slats and DAPs and all the traditional planning that's been used for decades to clawback, it just seems way beyond what they've done. It sounds like, to me at least, that what they've tried to do in these proposed regs is use a scalpel and not a sledgehammer, and identify planning that they felt was, for lack of a better term, inappropriately excessive. But it seemed that they very reasonably left much of the planning that most people have done that was not, let's say, riskless or pain-free planning safe. And even the graciousness and generosity with the dessous and the way they permitted that, I thought was very reasonable. I would hope they don't come back and make it more restrictive even still. At any rate, I
doubt they will.
Yeah, I hope so too, but you're right. You don't know until you know. I want to thank Jonathan Blattmacher and Professor Mitchell Gans for joining, and Interactive Legal ILS and Peak Trust Company for sponsoring. And I hope that you found this program as informative as I did. I feel like I learned a tremendous amount just listening to Mitchell and Jonathan. So thank you, everybody, and good luck.